Amen.
And how much time do you wish to reserve, if any?
The maximum 5 minutes, please. Thank you. May it please the court, Attorney Mike Callow for Mr. Warrington in this case, counsel. I would ask to reserve the maximum amount of time in this case for rebuttal. Your Honor, this is a case on a domestic violence situation, and of course no domestic violence cases seem to be simple or straightforward. But in this case, I think it's a case, what I would say is like obscenity, you know it when you see it. And if you read through the transcript in this case, I think you see the pattern that takes place in closing arguments, which is to attack the defense counsel, then attack the character of the defendant, to then testify as to things outside the record. In this particular case, there's testimony about how cell phones work and how landlines work and how directional listening works. And then you attack the defense counsel again, and then you sit down and you say, see, we've proven our case. And it's one of those cases that I would suggest to you, it's a situation that you see it. You know, I don't know how to define it, I don't know how to specifically say it, but you know it when you read it. And this is the type of thing that's happened in this case. I would also indicate also that, again, you see it, I think, when you read through the transcript and you see the allegations that this was ineffective assistance of counsel. This trial, in my opinion, was more about the arguments between counsel than it was about the case. In fact, Judge Kimbler, who tried the case, on many occasions, you can see his difficulty with counsel, on many occasions telling them, whoa, 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 slow down, stop. That is the type of behavior that I think this court should raise its attention to, in saying that Mr. Warrington has a right to effective assistance counsel. Mr. Warrington has a right to a fair trial. And when counsel engage in that type of repeated argument and fighting amongst themselves, I think it is raised to the level of ineffective assistance of counsel. So in both ways, both with the state of Ohio's attorneys as well as Mr. Warrington's attorneys, I think you know it when you see it in kind of situation. In this particular case, defense counsel did not object to the police report being entered into evidence, which is clearly hearsay, and there's replete. He didn't object to his client constantly being called a drunk or referred to as a drunk. He's referred to in the closing arguments as being an alcoholic. Clearly that's not in the record anywhere. But on page 325, you'll see that the prosecutor's office refers to him as being an alcoholic. He doesn't object at all during the closing arguments. He doesn't object at all during the rebuttal closing arguments when Mr. Razavi for the state of Ohio is clearly testifying and clearly giving his personal opinions. Talks about, can you imagine what Mr. Warrington is like when the police officers with guns are watching him? You know, these are inappropriate arguments.
When the police are what?
When the police are not watching him. What he says is, can you imagine when he's not in front of these guys with their guns standing there, and he's got these two women in the household, in this household, telling them to be quiet, and he goes on. Clearly, from both standpoints, I would argue that both the state of Ohio should not be making those arguments, and defense counsel should clearly be objecting to that, asking that the judge get involved in those situations.
The state
challenged
your assertion that your client was referred to as a drunk, and said that that is not in the record of the trial, and that the statement that was made was that he was drunk. Do you agree that assuming that their position is true, that is a distinction?
I believe it is a distinction, and it's a good point that they raised to be commenting on intoxication. What I would indicate is, I count, I think, over 40 references to him being drunk. He's referred to on page 325, it says, quote, the man's an alcoholic. I think that it's an important distinction that they raise, but I don't think it defeats the argument. When you keep in a derogatory manner referring to him as a drunk, talking about his past conduct, his prior conduct, asking the jury to imagine what he's like when the police aren't around, and imagine what he's like in his home. I think that is outside the bounds. And to me, I would argue that, I know it when I see it. I just think that's outside the bounds. I don't think that that's appropriate subject matter for closing argument. And you can go at it a lot of different ways. Not only is it not appropriate, but it's clearly asking the jury to imagine themselves in the shoes of his wife, or imagine in the shoes of his daughter. That would be inappropriate. He's commenting on things outside of the record. I mean, we don't know what this man is like a week prior to the incident or 2 weeks prior to the incident. We don't know what he was like yesterday. And yet that type of commentary is, in my opinion, inappropriate. So again, I think this is the case where you just know it when you see it. And I think that the defense counsel in this case was deficient in not making any challenge. I think more caught up in arguing with the prosecutor himself on their own differences. And I think consistently the state of Ohio is out of bounds in its closing arguments, again emphasizing arguments with counsel over commenting on the facts. We would ask that you overturn the conviction for that point. And again, for the record, Mr. Warrington has served his sentence and has been released. Thank
you. Good morning again, Your Honors. I'm Matthew Kern on behalf of D. Holman, the Medina County Prosecuting Attorney, and I still represent the state of Ohio. I'd like to start, since it seems to be the focus of the argument today, with the second assignment of error, the claimed instances of prosecutorial misconduct. You heard a very interesting intro roadmap to the defendant's argument today about attacking the character of defense counsel repeatedly and consistently throughout argument, and then sitting down and saying, well, we've proven our case. A couple of interesting points to note on appeal is that the defendant in this appeal doesn't say where those claimed instances happened in the record. There are no transcript sites on brief. There's one transcript site here today at oral argument for the first time ever in this case. He doesn't say...
Are you excluding the statement of the facts when you say that?
Yes, because his closing arguments aren't evidence, so they're not factual. The prosecutor wasn't testifying, as Mr. Callow seems to be insinuating. The prosecutor was making arguments based on the evidence, and as the Supreme Court and as this court previously and as courts around the state have held, that's not improper. If you can make arguments to a jury about what they should find based on the evidence presented.
But my point is, I just want to make sure that I understand your statement when you say that there were no citations to the record. You mean specifically related to the issue of prosecutorial misconduct?
Correct.
What happened in closing?
Correct.
Okay.
I mean, in the defendant's brief, beginning at page, well, wherever his assignment of error starts and then ends, there are no citations to the transcript in those pages pertaining to the second assignment of error. None. I don't know, as the state, I don't know where those claimed instances are supposedly happened. I don't know what specifically he's complaining about. I don't know what specifically or how he claims the prosecutor erred. The extent of his argument is the prosecutor committed these bad acts, period. There's no further analysis, there's no citations, and there's no case law. The only case law that he cites in the prosecutorial misconduct section are the two previous decisions of this court in older cases, and he doesn't even analyze those. He doesn't say those cases held and then defines the conduct. It doesn't say those cases describe situations where and then says what happened, or analyzes how those cases are analogous to this case. None of that is done here. It's like a 2-paragraph assignment of error. That's insufficient. That's not enough. It doesn't put me as the state on notice of what the claim is to respond to it. It doesn't put the court in a position where it can analyze the claim, conduct its own research, consider the record, look exactly where he wants the court to consider the argument, put it in context, and then consider, is it improper? Does it undermine the defendant's right to a fair trial? This court is not in a position to do those things because the argument was not enough. It doesn't put either of us, the court or the state, in a position to figure out what it is he's complaining about and analyze it. Where those instances occur. I mean, a great case in point, if I could make a crossover, is to the first assignment of error, where he says that trial counsel was ineffective for not objecting during cross-examination of the defendant. Well, when you actually look at the cross-examination of the defendant, trial counsel did in fact object several times. Repeatedly. So not only are his claims, do they fail to cite to the record, but when you do go back to the record, it turns out that they're not actually supported by the actual record. A couple of instances, he says introducing a police report as evidence. The police report wasn't admitted as evidence. The exhibit he's referring to, which again he doesn't cite to on brief, is Exhibit 8, and it's actually a written statement of the wife, which was not admitted as an exhibit. It was marked and introduced to refresh her recollection, and to because she was clearly testifying inconsistently with the statement. It was used for impeachment purposes during cross, but it was never introduced and admitted as an exhibit. That claim is completely belied by the record. A straightforward reading of the introduction of the transcript where the court reporter lists the exhibits and whether they were marked, introduced, and admitted shows that it was not admitted. And the court's discussion at the end of the case in chief and at the end of the case shows that the exhibit was not admitted. Where this claim comes from, I simply do not know. He claims that it is improper to refer to the defendant as a drunk, except that was never done in this case. Careful review of the record at several places throughout both cross-examination of the defendant and the prosecutor's closing arguments shows that he never called him a drunk. The prosecutor argued during closing arguments that his ability to recall events that evening as he testified, because the defendant testified in this case and therefore placed his credibility at issue with the jury, and describing events differently than other witnesses, the prosecutor impeached him and said, well, were you drinking that evening? Well, yeah. Well, how drunk were you? Oh, I wasn't that drunk at all. Okay, well, but you've consumed alcohol several instances before, right? Yeah. Did you? And the point of the questions was the prosecutor was impeaching his ability to accurately indicate how intoxicated he was, which has ramifications for how much he remembers of that night, how accurately he's recalling information during his testimony. That's relevant impeachment. During closing arguments, he never calls Mr. Warrington a drunk. He says he was intoxicated and refers to his cross-examination and says he's an alcoholic. Now, that's not bad character.
Well, but to say someone is an alcoholic suggests that there's some evidence by someone, offered by someone who is an authority that, to say that he is addicted to alcohol. I mean, how do you just...
The defendant admitted that he was an alcoholic. He said that he drank repeatedly over time and that he had a problem.
He said that he had a problem?
I mean, he said repeatedly that he drank alcohol to excess on multiple occasions over a long period of time.
In response to questions from the state?
Correct. But for the closing argument purposes, that was admissible evidence upon which the state could rely to talk about the witness's credibility that the jury had to weigh. Now, the prosecutor didn't cross the line in saying that I don't believe him, therefore you should convict. The prosecutor never said that. The prosecutor said, ladies and gentlemen, you heard the evidence, you get to consider the credibility of witnesses, and one of the things you get to consider is a person's history. Do they accurately recall information? Do they have a bias or a reason to lie in this case? You can consider all of that, and as specific instances, you can consider points, the evidence that came out during trial. Nothing about that's improper. Otherwise, what's the point of closing arguments? If the witness testifies on the stand, X, Y, and Z happened, and then two other witnesses say, yep, X, Y, and Z happened, the prosecutor can't stand up before a jury and say, ladies and gentlemen, so-and-so testified X, Y, and Z. Two other people said X, Y, and Z. You can find that that testimony is not only straightforward and understandable and logical, that it follows your common sense understanding of how the world works, but that two other people said it happened. That's not improper. What's the difference between that and the defendant testifying this happened and not being able to rely on it as a reason to judge their credibility? That doesn't make sense. Clearly, the state has to be in a position to comment on what happened at trial and argue to a jury what conclusions they should draw from that evidence. To do so otherwise hinders both the state and counsel, defense counsel, from being able to make persuasive closing arguments to a jury about what they think the evidence has shown. The Supreme Court of Ohio has repeatedly held that is not improper. State versus DR, 120 Ohio State 3rd, 460, paragraph 221. Another death penalty case, State versus Powell, 132 Ohio State 3rd, 233, paragraph 164. This is not improper conduct on the state. The state made common sense arguments in response to the defendant's closing arguments. This issue about the directionality and volume of a call was specifically brought up by defense counsel in their closing arguments about, well, no, the call couldn't have happened that way because, you know that the landlines they're louder than cell phones or something to that effect. And the prosecutor stood up in rebuttal and said, ladies and gentlemen, you know, use your common sense. Maybe you have some experience with cell phones. You know, that's for you all to decide amongst yourselves using your common sense and experience. But I suggest to you that, and made the argument. He didn't say this is true, he didn't testify, he made an argument in response to defense counsel's argument. Now if that evidence was outside the record, in terms of what the testimony presented, it was outside the record from the testimony from when defense counsel made the argument as well. All the prosecutor did was respond to defense counsel's argument. That's not improper. State versus DR, 120 Ohio State 3rd, 460. It's not improper to argue evidence and assert conclusions the jury could draw from that evidence. State versus Durbin, 2004 House 2201, paragraph 28. DR, paragraph 213. And State versus Melton, a 3rd District case, 1982, page 4. Plus, the defendant doesn't argue prejudice here. He concedes by the statement of the assignments of error presented that there is sufficient evidence and the conviction is not against the manifest weight of the evidence. Those are not assignments of error before the court today. The defendant is not contesting his guilt in this matter. The only issue that he's raised is ineffective assistance of counsel, which, again, no citation to the record aside from a lone citation to State versus Leonard for improper to admit police evidence as hearsay, which, as argued already, didn't happen. And 2 cases from this court about prosecutorial misconduct. Those are the only analysis or case citations the defense counsel makes in this case. He doesn't do any further analysis for you. He doesn't cite beyond the statement of the facts in terms of what happened that evening. He doesn't cite places in the transcript of what happened at trial, which are his only 2 assignments of error. He doesn't say, this is what happened at trial, that's how it affected my client's rights, this is how it was improper. He doesn't do that analysis for the court. It puts me in a weird position because by not objecting to the closing argument, he forfeits all but plain error. He concedes that. But then he doesn't argue plain error. He doesn't, he doesn't object to the claim of misconduct at trial, forfeits all but plain error. State versus Long says this court should only notice that to prevent a manifest miscarriage of justice. That's 53 Ohio State 2nd 91, paragraph 3 of the syllabus. But then he turns around and he doesn't argue plain error on appeal. He just says that's improper, you should reverse because Hartman. That's not enough. He has to argue why it constitutes plain error. That's under this court's decisions recently. That's a reason why the court should overlook the assignment of error. State versus Sykes, 9th District 2011, Ohio 293, paragraph 8. And State versus Geiger, 9th District 2012, Ohio 4002, paragraph 15. His failure to cite to the record violates his duty under Act Rule 14CA008080 and Local Rule 7B7 to cite to the record and make an argument if one exists. It's not this court's duty to look back at what his claim might be, construct an argument on his behalf, figure out, without the benefit of the state's response, whether that argument holds merit, and then consider the case. State versus Thompson, 9th District 2012, Ohio 2559, paragraphs 16 and 20. And State versus Blunt, 9th District 2014, Ohio 3533, at paragraph 26. There's simply not enough work done in this case by the defendant to warrant a reversal. None of his arguments are fleshed out enough for the court to actually consider them. And when you actually do some work on the defendant's behalf, it turns out that all the arguments he makes are not accurate. The police report was not admitted as evidence. A witness statement was marked for cross-examination purposes, but it was never admitted. It fails. He says. Just for your
knowledge, you have a couple minutes left.
Thank you very much. I want to transition to the ineffective assistance portion for a second. The same Act Rule 14CA008080 Local Rule 7B7 arguments apply to this claim as well. There's a couple of points that I want to make in response to some of the merit issues he makes. He says that the defense counsel failed to object to cross-examination of the defendant. Well, transcript pages 291, 294, 295, 298, 299, and 302 all show objections by defense counsel during cross-examination. Did he read the transcript? He claims the defense counsel failed to object to leading questions on cross-examination. I'm going to repeat that. I know I'm running short of time. He claims the defense counsel was ineffective for failing to object to leading questions on cross-examination. Evidence Rule 611C specifically allows leading questions on cross-examination. And, as noted in the state's brief, trial tactics books from a long time have suggested the very form of cross-questions that the state used during cross-examination of the defendant. Nothing's improper about that. There is no reason for defense counsel to object. He says that the defense counsel failed to move to suppress evidence in this case, but he doesn't say what evidence should have been suppressed. He doesn't say on what basis the evidence should have been suppressed. He doesn't even show why that motion would have been granted. He says the defense counsel failed to object to evidence of the defendant's drinking. Doesn't cite any authority in support of that claim. Only says, the prosecutor only said the defendant was drunk that night, not that he was a drunk. And it was strategic for defense counsel to allow that evidence because the claim at trial that he was pursuing as a defense was that the defendant was so intoxicated he couldn't form the requisite mental state to commit the offense. That was his strategy.
With that, I'm going to have to ask you to conclude.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. In rebuttal, I would bring up a couple issues. One, I think this court clearly sees, as I think this case is about when you see it, you know it. You can see what happens when you challenge the prosecutor's office in this town. You get a deluge of attack.
The merits.
Well, you get a deluge of an attack, and that's what I'm saying in this case. So the rebuttal argument in this case, a closing argument, what you can see is the pattern that happens, and you see it because you called it out in the Hart case. You called it out multiple times, and you see the pattern. The closing rebuttal argument starts off with an attack on defense counsel, page 348, follows up with comments on landline use, comments on cell phone use, testimony from the prosecutor's office, follows up with testimony again that the prosecutor indicating that this story is preposterous, testimony again that says that just because defense counsel says it makes sense, listen to me, my job isn't to convince Mr. Gigiano. I'm getting the feeling there's no possible way to do that. This is what happens every time in a trial, and you've seen that pattern. And I'm asking you to read the transcript, see it know it when you see it, and I'm asking you to take action. We can't continue to have people called alcoholics when there's no evidence. I mean, if being drunk to excess more than one time becomes you an alcoholic and gives them a permission slip to call you an alcoholic, that shows a complete misunderstanding of the disease and a complete misunderstanding of how derogatory their characterizations are. So I would ask that you know it when you see it and reverse the case and get involved. Thank you.
Thank you. We will take the case under advisement, send you a copy of the written opinion that was issued, and of course you can also find it on our webpage. Thank you and have a good day.